just to amplify this issue of Rule 34 here for a second, bears reading out loud here for a moment, that the ESI has to be produced in form or forms in which it is ordinarily maintained, or in a form or forms that are reasonably usable. As lawyers, as practitioners out there, if you wind up working with electronic discovery as litigators, the issue of what is or is not reasonably usable is actually the battleground. I mean, how is a TIFF file reasonably usable if I can't search it? I would argue no, and courts tend to agree with you there, but other courts have gone the other way. In that vein, I would point out the advisory committee notes to the 2006 amendments, that the option to produce in a reasonably usable form does not mean that the producing party is free to convert the ESI from a form in which it is ordinarily maintained to a different form that makes it more difficult or burdensome for the requesting party to use efficiently in the litigation. If the responding party ordinarily makes the information it is producing in a way that makes it searchable by electronic means, the information should not be produced in a form that removes or significantly degrades this feature. I can't, again, it's probably getting ahead of things a little bit for you all as you're coming out of school, but there are entire teams of lawyers and IT specialists who work in-house at larger companies now who actually myopically focus on just these kinds of issues, meaning, can I maintain my electronically stored information in a way that's usable to me on my in-house capability, yet at the same time, when the time comes that I actually have to give up huge, huge volumes of my data, that it's just going to become so cumbersome and so useless to my adversary that I'll be able to, that I could basically have it both ways. I'll tell you right now, we do a significant amount of work for a number of different investment banks in New York. They now have in-house staff of 10 to 20 attorneys who do nothing more than focus on electronically stored information issues, who focus entirely on how it is that they are going to try to operate within the purview of Rule 34, but yet keep themselves in a situation in which they're not giving up the keys to the kingdom when they actually produce the data to the other side in a piece of litigation. The core issue, obviously, that Rule 34 is getting at, and that I've alluded to already, is just whether or not you're going to produce something natively in a native file format, or you're going to actually produce it in a static format, which is not going to be searchable and will not be as usable to the recipient of your discovery. Just very briefly, the Sedona conference, just giving you a quick definition of native format, which you all probably know because of your interest in the Cyber Law Society, but it's electronic documents have an associated file structure defined by the original created application. This structure is referred to as the native format of the document. So again, what you'll find happening as time goes along in a number of electronic discovery disputes is that folks are looking for native production. The reason why you want native production is because metadata is going to be attached to the native production, and you're going to actually have a much more robust amount of information that's available to you as you are trying to figure out what, in fact, this document that you've received from your adversary actually means. On the issue of native file production, as I had alluded to earlier when we were going through Rule 34, if there's no agreement, then the default under Rule 34 is how the information is ordinarily maintained, or that the form or forms are reasonably usable to the recipient. I'll tell you the impact of that on my own practice, on practices of people who worked in electronic discovery, is simply that when you serve a subpoena or you serve a document request now, you actually have laid out specifically how you were calling for the information to be produced to you. You now can take the opportunity to get ahead of the curve and say, I now have an understanding after the Rule 26F conference of how your system is set up. As it relates to these particular files, this is the format that I want them in. As it relates to these other files or these other directories, I want them in this other manner. And again, it gets you to a point as a litigator, as a practitioner, in which you're really marrying together the various opportunities that are now presented by the fantastic software applications that exist for reading metadata and searching and coding metadata, you can marry that together with the information that you're actually getting from your adversary. Metadata, why does it matter? It's data about data. It tells you everything. I could probably count on two hands the number of cases in which information that has come out of metadata has actually been a crucial point of the case, been a crucial point of the determination of whether or not there's any merit to the claims that are at issue, or whether or not you're going to defend the case or you're just going to settle it. You see the entire life history of that particular electronic file. How, when, by whom it was created. You know, it was created, it was modified, it was transmitted, it was viewed. I mean, every single thing that's possibly out there about a document, it's all going to come to you. Well, I shouldn't say more importantly, but paralleling that in importance is the fact that when you receive a document in metadata, which, by the way, it will take you all, as you start to practice, you got to look at metadata for, you know, it took me 4 to 6 months of looking at metadata before you started to, straighten it out in your head, because it's kind of gobbledygook, because it doesn't look, what would appear as, the instructions to build the page and to load the page all actually show up in the header of the metadata, and then you actually get into the text. So it takes you a little while to get used to it. But the great thing is that email attachments are actually embedded in the metadata. You don't lose the attachment. And the attachment on an email, I, again, can't tell you enough how often cases in civil litigation in New York turn upon what was or what was not attached to a particular email. What version of the document was actually sent in the attachment to the email? Who looked at what version? When did they look at that version? Particularly in civil disputes, it's often a very, very critical issue, and one which folks spend a lot of time focusing their attention on. On the flip side, the other reason why I like metadata, the other reason why I want it, is because it's searchable. I can also, it's navigable. I can find documents that I can say, I only want documents that Morty has looked at. So I've got 4 million emails that were produced to me from the other side in a dispute, and I can say, I'm looking for anything that Morty had worked on, and you can get down to the 72 emails that Morty worked on. So that when you then have an opportunity to take Morty's deposition, you will have the opportunity to know exactly what he was looking at before on the particular issue that you're talking about. Makes the process of civil litigation in the United States a hell of a lot easier when you have metadata in front of you. That being said, do you actually have to produce metadata? There's a very real issue that's presented on this. The question is absolutely outstanding right now. The NASCAR case out in Kentucky, the answer is no. And the reason why is because the judge, as you can see right there, took it upon him or herself to write, most cases and for most documents, metadata does not provide any relevant information. Without a showing of a particularized need for that data, the court said that the metadata wouldn't get handed up. That echoed a case that had come out shortly before that in the District of Delaware involving Wyeth. Again, metadata was of limited value, and in fact the court in that case went further to say that there was a presumption against the production of metadata. I can tell you all, however, having litigated a metadata issue in the Southern District of New York this past summer, that while these cases are out there, you can also argue around these cases. And in the particular case that I had, which was a computer software case in front of Magistrate Judge Peck in the Southern District, we did get the metadata produced to us. Just to put a little bit of a flavor to how and why people care about metadata and litigate the issue of metadata and why it is worth it for someone to actually go in front of a judge and argue for metadata to be produced. In the particular case that we were working on, the other side was trying to effectively give us 725,000 static documents that we would just basically a huge data dump that we would have to hire all of you people to flip through page after page and figure out what the hell was inside of it. And by getting it in the form that we did in metadata, we're able to actually use it, search it. We're able to do a hell of a lot more with that information in a fraction of the time.